So both the Muslims and the ruling power of the time considered them to be a nation. They rejected minority, and we are trying to give that imprint. Kindly have the last page at page 38. The third line. That was the time, Lord, when Chiang Kai-shek was visiting India, when the INA forces had marched and reached Imphal, Lord. The third line, India is not one national state. It's two major nations being Hindus and Muslims, and 1/3 of India is under the princes. So unlike the case of industry and property, etc., where the rights were in existence and our constitution transmutes it into a higher level, protected it by fundamental rights under 1901. But here, something which they are rejecting, which don't agree with, we are then by 30, and this is all past part of history. I can multiply number of documents, but this is just to give an idea about what they were thinking. And the person who's said to be the founder, his ideas of separate nation continued to grip AMU. That is why, Lord, what was told to your Lordship that when the President, or at that time Vice Chancellor Zakir Hussain, visited, he said that the future will depend upon how ALIGARH looks to India. That was what was told to your Lordship from the appellant side. Why was this said? Because ALIGARH was with Pakistan movement. And a large number of students and teachers all migrated to Pakistan also. No, these are facts, Lord. I don't think, Lord, that it should be inconvenient to any person that this is being stated. But because we must face the truth and then see whether 30 can still be applied.
Yes, Mr.
Now, kindly have the main volume melodies of my submission to H. Before page 8. For a Lordship's convenience, I will not read all of this, but this is from the Woods Dispatch. Which we have enclosed as R1. I have extracted the relevant portion.
Page
8, paragraph 11B. 11A is Macaulay's extract. That minutes of Macaulay is also enclosed as R6. Page 9 is the relevant portion, that is para 35.
5H.
Plus the 11B at page 8. And kindly come to these are full documents are in volume 5H.
Where will you get the volume?
5H. Because the Hunter Commission, etc., is pretty thick volume, so we separately. All these documents in this written submission are separately compiled in 5H. Now please turn to page 9. Para 35 from that document, Woods dispatch. We shall be ready to sanction the creation of an university at Madras or in any other part of India where a sufficient number of institutions exist from which properly qualified candidates for degrees could be supplied. It being, in our opinion, advisable that the great centers of European government and civilization in India should possess universities similar in character to those which will now be founded. As soon as the extension of a liberal education shows that their establishment would be of advantage to the native communities. Now, both the words founded and establishment are simultaneously being used, and the objectives are similar. Now, please turn to page 11. D. So, para D. Between 1857 and 1882, no other university had been established. The Hunter Commission was appointed by resolution of Government of India dated 3rd of February 1882 to review the progress of English education made in India. Specific instructions were given to the Commission with respect to primary education, secondary education, and colleges to examine further involvement of private efforts under the grant in aid system. That is Hunter Commission report, para 10, page 626. It is noted in the report of the Commission that after the disappearance of British East India Company, the principles of dispatch of 1854 had been confirmed by the Secretary of State in the dispatch of 1859. In para 46 of the report related to the Indian universities, the same is quoted below. Now see at page 12, the last bold lines of this subpara D. This is regarding Lahore. Dr. Leitner was a very prominent place. It is mainly an examining body, but exercises variety of functions for the promotion of literature and education. Its distinguishing features are that it owns its origin to other than state efforts, and that is designed to give special encouragement to Oriental studies. So somebody or the other obviously will go and request that now we need in the northwest frontier provinces, we need a university. There's no university. So merely because somebody is requesting, contributing some little thing, yes, ma'am. So therefore, Lords, at that time, there was no policy. That's what I had submitted. And these documents show that up to the level of college, private efforts, grant in aid, otherwise there was no policy. Now with But may I now move on to some 2-3 aspects of the Act only, because almost everything has been covered, so I don't want to retrace all those things. If your Lordship has Volume 4C,
Volume 4 seems to do the
4C, page 40.
In this case, who are the two nodal council actually? You are the. If you can just overnight, maybe give us a master index, like we had in Article 370, with Act to be found in this. The documents you can give us a master index, then the judgments. So Basha, other judgments, which are the volumes. So it becomes easier when you are dictating in the end, or even to read it before the, as we go along. Just put it in a plastic, or just on any paper, and we'll give it to the court master, so he'll circulate to all 5 of us.
And
Yes.
page 40 at the bottom, Mr. Shafi, who's introducing the bill, he is a member of the council, executive council. Sir, I beg to introduce the bill to establish and incorporate a teaching and residential Muslim university at Aligarh, and to move that bill be referred to a select committee consisting of the Honorable George Lowndes, the Honorable so-and-so, Raja of Mahmudabad. There were 5 British persons in this select committee and 5 other gentlemen. Raja Mahmudabad, Asad Ali, Khan Sahib, Shah Nawaz Bhutto. I hope not this name rings some bell. He is the father of the Prime Minister of Pakistan.
Of Mr. Zulfikar
Ali Bhutto. And there's something more very significant. All these 5 gentlemen ultimately were Pakistan supporters. And Shahnawaz Bhutto is the person who in January 1947 came from Karachi and became the Diwan of Junagadh, Nawab Junagadh. The Nawab himself was holidaying in London. Mountbatten never summoned him for accession like he was doing with all others on 3 subjects. He comes back, Nawab comes back on 11th of August and signs accession in favor of Pakistan. And along with his numerous dogs, he vanishes to Karachi. Shahnawaz Bhutto continued there to rule.
In Junagadh.
From Junagadh. And when this accession happened to Pakistan, then there were 2 other principalities, that is Mangrol and Babariyawad, which had been attached during World War with Junagadh. So they declared independence and acceded to India. Then Shahnawaz Bhutto sent his forces to occupy Babariyawad in Junagadh. Then, cutting the other part of the story short, what happens is that Indian forces are sent, which take back and surround Junagadh. It is then that Shahnawaz Bhutto, through the sea route, vanishes to Karachi, and the Junagadh was regained. So these are all forces, all these 5 gentlemen went there. In the negotiating team, M.A. Jinnah was also involved, which was negotiating the bill. And he was one of the persons who said that now, since it's it's all India importance university, therefore, instead of Lieutenant Governor of Northwest Province, it will be befitting to have the Governor General as Lord Rector. So this is one aspect which I wanted to point out to your lordships, that the British, in the scenario of Rowlatt Act 1919 and Khilafat movement, the discovery of oil in the Middle East, and obtaining of the mandate in Palestine by the British imperialists, all these circumstances, certain things were being done by the HMG and the Governor General, which is known to everybody. Drive a wedge. You also will find at the next page, 41 bottom, that this process began in 1911. The request. And it was granted only when they agreed to BHU in 1919. It took them 8 years to have that act. This is one aspect. The second aspect is what is the significance of this office of Lord Rector? None of the universities which were created, established by the Governor General in Council, had this office of Lord Rector. We were told by the appellant's side, my lord, that all universities have got visitors. So what is so great about it? There are visitors, there are chancellors, vice chancellors, there's some supervision, some regulation. So now I'm trying to make an effort to apply these principles of 30 backwards and see what's the consequence. Can we say that it was established by the minority? This special office of Lord Rector and Governor General as Lord Rector was only in these two universities, BHU and ALIGARH Muslim University. The second feature is that unlike the visitors, even in the acts passed subsequent to the independence under the Constitution of India, the visitors have a very limited power of supervising, causing an inspection to happen, and giving a show cause, giving some advice and directions. Nothing else. No visitor in no university, public or private, has got a power to make, approve, amend, modify statutes, ordinances. So in contrast to the visitor, the Lord Rector has very wide powers. One, the first statute and the first ordinances are all made by the Governor General in Council. And no amendment can be enforced merely at the will of the court or the visitor's body, visiting board. It must get the approval. So ultimately, amendment can happen only at the will of the Governor General and nobody else, the Lord Rector. The statutes, the third, my lord, the statutes and the ordinances are the life and soul of a university. All universities function in accordance with that. The ALIGARH Muslim University Act provides specifically that admissions will happen in accordance with the statutes and accordance with the ordinances. So all policies in accordance with statute and ordinances. The court meets once in a year. So where is the control in the court? merely because the name has Muslims and the court has Muslims and de facto there have been Muslims. It's all fine, no problem. Nobody has problem with that. Muslims are also Indian citizens, like anybody else. So if the majority of students there have been mullahs are Muslims, so Muslim vice chancellor and can be appointed, but that doesn't mean that they have established, therefore we take it again back. This de facto is also rolled back to 1920 to find out the establishment. As I submitted, the main part of the establishment under Article 30 is the framing of the scheme of administration. Please mark the words, right to establish and administer. The right to administer has to be in accordance with the scheme of administration which happens with establishment.
But then aren't you drawing distinction between administration and legislation part in your own argument itself?
No, there's no contradiction. With great respect, establish, when you establish a university, supposing, let's take a hypothetical case. Today we establish a university, the law comes, X university is established, there's no framework. This is what happened in Yashpal. The appellants rely upon Yashpal. In Yashpal, by notifications under Act, universities were established, there was the shop. X university established in this shop, Y in that shop, and third in this house. No infrastructure, nothing. The court says no. If private people are establishing, then there must be infrastructure, there must be faculty, there must be all minimum rooms, etc., for where students will study. And until that is done, it cannot be incorporated. So what happened there was just incorporation of shops and houses and so on, and piece of open land university established. Government, they said, may do that because government has obligations, constitutional obligations. It will establish, it has funds and everything. But one must know, there are no university shops. Therefore, when you establish a university, the scheme of administration has to be part of it. Who is going to be chancellor, who is going to be vice chancellor, how principal will be appointed, how employees will be appointed, how students will be admitted, how discipline will be maintained. So there has to be a framework. And that is what Justice Vanchu's judgment, Milord Aziz Basha, does. It looks into all the provisions and finds that the entire scheme of administration has been provided by the Act. Their role in the framing of the scheme of administration is very minimal in non-essential parts. Otherwise, BHU framework was there, you have to follow that. Some little changes were done because university became a central subject. So this rector, my lord, is a concept borrowed from the London universities, especially the 1858 Act where Scotland University was formed. From there, my lords, they took this. And rector, my lord, is considered to be a leader of the university. So this is not a mere change of nomenclature that instead of visitor, we are having rector. And who is made, Lord Rector? That's added upon it, the Governor General, the supreme power on the soil of India. Nothing prevented the Governor General and Council from saying, my lord, that this MAO college is MAO university, as it is, and asking them to make some changes about visitors, etc. And just as today the private universities are being formed, they could do anything. There was nobody to question, no judicial review. But they don't do it. They keep the power and entitlement to establish university to themselves. And this is the Lord Rector note which is provided. Entire scheme is generated from having the source in the Lord Rector. the Governor General in Council, with the sanction of HMD. Before this was established, sanction was taken from the Secretary of State in London. One last thing about this, my lord, is look at the court also, my lords. Volume 2B, my lord, is Solicitor General's submission. The Lordship will not find the 124 members are the founder members. In the statute, the Act says members will be as per the statute. The statute has ordinary members and founder members.
Which page are you reading?
I'm just giving that one of the six statute number. Members all of them, sir. Yes, kindly have statute number 8, which is at page 160. Class 1 is ex officio members. Class 2 is foundation members. Class 3 is life members. And class 4 is ordinary members. Now kindly come to the annexure, my lord, which is containing the names of the page 167. There's hardly any connect with the MAO college. It's past students, past teachers, or those who were from all over India, from even Indian states. The Nawabs are members, retired director of public instruction. Almost half of them are in the service of British government in different parts of the countries, from Northwest to Bengal and from Kerala to here. Not one person. Some of them are even judges, 46 judges have high court, district judges, magistrates. 79 is Nawab Justice Sir Syed Shamsul Huda, High Court, Calcutta. So all over the place. Item 81, Muhammad Ali Jinnah. So people from Karachi, Punjab and all, 124 members in all. These founder members, Lord, are supposed to, under the statute, retire, like in Rajya Sabha, Lord, 1/5 retires every year. And so for at least after 5 years, 6th year, 7th year, 8th year, 9th year, like that, they will retire. So for 10 years, this is the founder members court. So they are Muslims, all right, but nothing to do with MAO.
They were all trustees of the MAO college,
All of them
all of them.
cannot.
Yes.
Will you show it?
Most of the facts they give are wrong, but then
You place the correct facts. Now with this, my lords, The last submission which I would like to place is about stare decisis. Stare decisis. Hmm?
What do you have to say on stare decisis?
Lord, before this, just a reference, Lord, in one of the queries, Lord, of my lords, there was allusion to a legally positive approach, Lord, in this, Lord. Or the submission is, Lord, that legal positivism, Lord, does not involve any retrospectivity. It only, Lord, is concerned with infusing whether moral principles, Lord, can be utilized to interpret statutes, Lord. So various authors, in any case, Lord, the gods of legal positivism, Lord, are not at one. They are varied and in conflict. So very difficult to choose, Lord. However, Lord, the best approach could be of Hart, Lord, or Austin. But that also it's limited to infusing moral principles. Our court, Lord, I have given 3 judgments at page 9 of my additional submission, where the lordships have rejected the infusion of moral principles. However, Lord, today we are talking about constitutional morality, etc. So, at the highest, Lord, even if we have to infuse and inject the principles of constitutional morality and drawn from the provisions of the Constitution, it would be to interpret, Lord, the Act. But we are faced with an entirely different question. Therefore, that approach, in my respectful submission, with utmost deference, Lord, may not be appropriate. With this, I come to stare decisis. What my submission is, as Solicitor General has already indicated, Lord, this is a stand-alone university. The act, stand-alone act, creating a university of the kind it is. The judgment in Aziz Basha is statute specific. It analyzes the particular act and comes to a certain conclusion. The third, my lord, is then the act was first amended in 1951 and then in 1965. Some individuals had come to the court. The ALIGARH Muslim University never intervened. And it had no problem with Aziz Basha, at least on the judicial side. They may be trying to get changes through parliament. Which obviously has to proceed on the footing that the judgment is good, and we have to alter the basis, etc. And whether they have succeeded or not is a different question. But the parliament also will proceed on the footing that the judgment is good and how to change the basis. Now, this judgment, my lords, being statute specific and concerning one university, has been implemented by the government for a long period of time. On the basis that it is not a minority institution.
On factual aspect, was there any reservation or preference given to the Muslims right from 1950 till 1981?
It's after 81 that this order was passed, which was challenged in the High Court.
No, I'm talking about from
No,
1950
not
till
my knowledge, not subject to correction by the other side. Actually, it wasn't required, because 80% already they were admitting. So
No, but was there any preference being given, or by even if there was no preference being given,
no policy of reservation.
there was no policy of
That's subject to correction from the other side.
after 81?
After 81, this order came in 85, reserving 50%,
And
which was questioned.
it,
2005. 2005, I'm sorry.
because what was said by, I think it was stated by them, preference was being given to the schools which were affiliated to the AME. And they were giving preference in admissions in the college itself.
So not perhaps in a formal way, but yeah, they were controlling lots, they were principals and all those, so therefore they were admitting that way. That's what de facto submission is, that the vice chancellors were there, the principal was there, and so on.
Show me the one on listening trustees learning.
So now this judgment, my lords, has been implemented. Now, please see, my lord, when MAO asked the Governor General to establish the university, what was their contribution in the MAO college? Look at the establishment today, which was shown to your lordships. It's not the same thing. 74 acres of land. And now, my lords, it is having 1,150 acres of land. The government of India is today's budget is 1,000 crores. There are today 17 halls, all subject to corrections. My learned friend will say it's all incorrect facts. 7-story building. But so there's a complete metamorphosis. It's no more that MAO college. What are we looking at? What are we wanting to change? This judgment in Aziz Basha has no impact on any other university which were created before. This is a one standalone university. So what are we wanting to do today? Because I can understand that this judgment is creating havoc with respect to minorities or something. There's no great public interest involved. Rather, all this money which has been invested by the governments in this institute on the understanding of Aziz Basha's position. Now that can't be taken away now, so we take back all those buildings, etc. You go and establish. Nobody has the right to a grant. There may well be, my lord, consequences which are adverse. So there's no public mischief happening. And I have, my lord, mentioned certain judgments. Page 6. At page 56 of volume 2H. Para 53 to 59. शेरवाई किसमें है? Kindly have para 58 minutes.
Which page?
Page 57, para 58. It's a quotation from Vaman Rao. The principle of stare decisis is also firmly rooted in American jurisprudence. It is recorded as a rule of policy which promotes predictability, certainty, uniformity, and stability. The legal system, it is said, should furnish a clear guide for conduct so that people may plan their affairs with assurance against surprise. It is important to further fair and expeditious adjudication by eliminating the need to relitigate every proposition in every case. When the weight of the volume of the decision on a point of general public importance is heavy enough, courts are inclined to abide by the rule of stare decisis, leaving it to the legislature to change law necessary. In Bernard so-and-so, Justice Brandeis stated that stare decisis is usually a wise policy because in most matters it is more important that the applicable rule of law be settled than it be settled right. 38. While dealing with the subject of stare decisis, Shri H.M. Sirvai, in his book on constitutional law, has pointed out how important it is for judges to conform to a certain measure of discipline so that decisions of old standing are not overruled for the reason merely that another view of the matter could also be taken. The learned author has cited an Australian case in which it was said that though the court has the power to reconsider its own decision, that should not be done upon a mere suggestion that some or all of it, the members of the latter court may arrive at a different conclusion if the matter were res integra, the Tramways case. The learned author then refers to two cases of our Supreme Court in which the importance of adherence to precedents was stressed. Justice Jagannath Das said in the Bengal immunity case that the finality of the decisions of Supreme Court, which is the court of last resort, will be greatly weakened and much mischief open to reconsideration. Much mischief done if we treat our own judgments, even though recent, as open to reconsideration. Justice Sinha said in the same case that if the Supreme Court were to review its own previous decisions simply on the ground that another view was possible, that litigant public may be encouraged to think always worthwhile taking a chance with the highest court of the land. Justice Hegde said in his dissenting judgment that the Supreme Court should not overrule its decisions except under compelling circumstances. It is only when the court is fully convinced that public interest of a substantial character would be jeopardized by a previous decision that the court should overrule that decision. Reconsideration of the earlier decisions, according to the learned judge, should be confined to questions of great public importance. Legal problems should not be treated as mere subjects for mental exercise. An earlier decision may therefore be overruled only if the court comes to the conclusion it's manifestly wrong, not upon a mere suggestion that if the matter were res integra members. So some other judgments are there, Lord, which I will not read on the same vein. Now, therefore, Lord, in this case, I submit that there is greater public mischief to happen if Aziz Basha is even reconsidered and possibly overruled, rather than if this is sustained, it has no impact on any other. There is no other past act of made by the Governor General in Council, so it has no other impact on trickle down effect. Why we should not? What are we looking for in this? No other benefit, and it's a judgment which has. We are now what 1968, 32 and 24, 56 years down the line, and for a standalone case, which ultimately would result in all this creation at the cost of public expense to be handed over to. And lastly, as I said, there is a distinction between established by, established for. In the worst case scenario, we look at the title Muslim University and the court Muslim. It would at the highest be a case where the Governor General is establishing the university for the Muslims. I have given in my written submission cases on by or under. By means directly by the provision of the act. And under will be something like this deemed university. Section 3 UGC Act, where we apply with all my infrastructure, everything, degree college is functioning, education level is high. And then the UGC recommends and government then sanctions and you are a deemed to be university. That is, and finally, this statute of recognition and statute of establishment. Aligarh Muslim University Act is a statute of establishment of university, not a case where the statute is merely recognizing some college which is already of the standard of a university. While establishing a university, the power that be can always infuse something from those people who are contributing. Sometimes they may be made trustee, sometimes they may be made some rector or something, which is decorative positions, patrons, and so on. And even if we have to deal with the judgments, Patro, etc., they are all judgments, Saint Xavier, etc., which the judgments which are of colleges and schools. So there's no question, none of those cases were considering they have all noted. I have pointed out that Aziz Basha has been noted in at least half a dozen cases. And even St. Stephen's blood accepts the definition which has been accepted by Justice Panchu. I have quoted that portion in my speech. Yes, sir.
Thank you, Mr.
I'm ready.
Devi. Thank you, Mr. Devi. Yes, Mr. Kaur. Yes, sir.
Look, I'll concentrate on three aspects. One is the scope of reference and why it's important for your lodges to see that neither is Basha under review or in appeal. And I'll show the reference order and three crucial orders by never ever in 56 years, even remotely, the correctness of Basha on the issue of AMU being established and administered has ever been questioned. The only question in the reference order which said remains undetermined or is yet to be determined is only with regard to the conjunctive or disjunctive reading of established and administered under Article 30, subclause 1. That's the first limb of my argument. In the second limb of my argument, my lords, I will refer to the judgments because a question which was never framed is sought to be framed by the appellants in their written submissions to say there are internal contradictory findings in Basha. That's their question they frame. And then go on to say that this is contrary to various judgments of the Supreme Court to show that that is an attempt to unravel Basha completely when there is no contradiction with the 6 judgments that they cite. That will be the second limb of my argument. And the third will, of course, be 3 or 4 principal submissions established through by, was the act really seeking to overrule Basha? Was it a validating act? Just 3 or 4 crucial submissions I'll deal with in the end. Now, first of all, my lords, Aziz Basha was the result of 5 writ petitions challenging the constitutionality of the 1951 Amendment Act and the 1965 Amendment Act. The challenge was principally based on Article 30, subclause 1 of the Constitution. And the petitioner's case in that matter was that AMU was established by Muslim minority and therefore the Muslims had the right to administer it, was their case. And they contended that the 1951 and 65 Acts took away or abridged the administrative rights of the Muslims, and thus the acts were ultra vires Article 30, subclause 1. Now, the Supreme Court, my lords, distinctly on three different issues said, as far as administer and established is concerned, it was held, as also held in St. Stephen's later, that they have to be read conjunctively and not disjunctively. The second finding was that AMU was not established by a Muslim minority but by the central government of the day. And thirdly, AMU was not administered by Muslim minority. The latter two, as I show the next few cases or four cases, never ever have been the subject matter of any discussion or being referred to a larger bench at all. It's all been about disjunctive versus conjunctive. Then came, my lords, the two-judge bench decision in Anjuman-e-Rahmaniya versus the district inspector. Now, what had happened was the people who had set up the society, some were Muslims and some were non-Muslims in that case. So the issue which arose in Anjuman-e-Rahmaniya was whether protection under Article 30, subclause 1 will be granted to an institution which has not solely been established by a minority. That was the one issue they were grappling with in that. And the other issue was regarding whether registration of a society under the Society Registration Act changes the status of the society from a minority institution to a non-minority institution. These were the two issues being dealt with in that judgment. It was in that context, they never disagreed with Basha, they never doubted Basha in any form. They referred it to 7 judges saying that we need to decide on the issue of essential conditions and ingredients of a minority institution should be decided once and for all. That was the basis of Rahmaniya. Now, as I respectfully submitted, my lords, nowhere was the findings in Aziz Basha regarding either establishment of AMU or administering of AMU ever questioned in this judgment. And they pertain to minority societies, not universities, that judgment. Then came TMA Pi Foundation, which dealt with the scope of minorities to deal with and administer an institution, and if aid is given, what are the nature of regulations which can be imposed, regulatory in nature, conditions that could be imposed. Therein, my lords, a question came to be framed, que Rahmaniya. And that question is the question 3 subclause A, which the reference order also refers to, and says that this was the question que Rahmaniya, which was framed in TMA Pi. And that question specifically, my lord said, would you lords want to see that, or should I just read that out? Yes. What are the indicia for treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a persons belonging to a religious or linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? And then they went on to say this question need not be answered by this bench. It will be dealt with by a regular bench. So the question was indicia and thereafter conjunctive or disjunctive. Whether AMU was administered by a Muslim minority, established by a Muslim minority, never ever questioned. TMFI again never questioned, in fact discussed, and then I come to TMFI, not for a second doubts what Basha said. Thereafter, my lords, while disposing of Anjuman-e-Rahmaniya, all that the judgment did, the two judges did, was that now TMFI is the law. All regulations, all orders, enactments, schemes, regulations will abide by TMFI. And if any question arises in future, it will be decided in the context of TMFI, and Rahmaniya came to be disposed of. Then came, my lords, the second reference order of 12th of February 2019, and that I'll request your lordships to please have once more, the reference order. Volume 3A, page 216. Yes, yes. Volume 3A, page 216. This court in S. Aziz Basha and another versus Union of India, inter alia, has observed as follows. It is to our mind quite clear that Article 30, subclause 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the educational institution, it will have the right to administer it if by some process it had been administering the same before the Constitution came into force. We are not prepared to accept this argument. The article, in our opinion, clearly shows that the minority will have the right to administer educational institutions of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it, and because for some reason or other it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read it gives the right to the minority to administer an educational educational institution, provided it has been established by it. We are of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution, even though the institution may not have been established by them. The two words in Article 30, subclause 1 must be read together, and so read, the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer it under Article 30, subclause 1. The judgment of the Allahabad High Court, which is under challenge in the present appeals, rejects the prayers made on account of the decision of this court in S. Aziz Basha Supra. The issue arising in S. Aziz Basha Supra was referred to a 7 judges bench uh, uh, by an order of this court dated 26 November 1981, passed in writ petition so-and-so Anjumane Rahmania versus District Inspector. The aforesaid writ petitions, that is writ petition number so-and-so, were heard along with other connected cases, TMFI versus State of Karnataka, by a bench of 11 judges, the judgment in which cases is reported as so-and-so. The question 3A, which was formulated for an answer in TMFI Foundation, which coincidentally reflects the question referred by the order of this court dated 26 November 1981, passed in writ petition number so-and-so, is as follows. 3A. What are the indicia for the treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a person belonging to a religious or linguistic minority, or it's being administered by a person belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench, passed on 11th March 2003, which for reasons that we need not dilate, did not answer the aforesaid question 3A formulated in TMA Pi Foundation Supra. The said facts would show that the correctness of the question arising from the decision of this court in Aziz Basha Supra has remained undetermined. That apart, the decision of this court and Professor Yashpal and another versus State of Chhattisgarh and another, and the amendment of the National Commission for Minority Education Institution Act 2004 made in the year 2010 would also require an authoritative pronouncement on the aforesaid questions formulated and set out above. Besides the correctness of the view expressed in the judgment of this court in Aziz Basha, which has been extracted above. Ordinarily and in the normal course, the judicial...
Just read this paragraph once again. For your argument.
9?
Yes, for your argument, just
9.
for first argument of yours. Just
9.
read it again. Yes.
Lordship wants me to read 9 again?
Yes, yes,
Yeah.
yes.
That apart, the decision of this court and Professor Yashpal and another...
Now, what was Professor Yashpal?
Yeah, Manoj, can I complete the para and then I'll answer that question. Then I'll answer that.
Okay, fair enough.
Versus State of Chhattisgarh and others, and the amendment of the National Commission for Minority Educational Institutions Act 2004, made in the year 2010, would also require an authoritative pronouncement on the aforesaid question formulated as set out above. besides the correctness of the view expressed in the judgment of this court and Aziz Basha, which has been extracted above. Now, my lords, the reason specific.
This paragraph refers to three things. One is the effect of Professor Yashpal.
Yes.
What did Yashpal deal with? And therefore, the issue which arises.
Right.
Second, it says amendment to the National Commission on Minority Education Act 2004.
Right. Right.
In 2010,
Right.
the second question.
Right.
The third question is with regard to correctness of the view expressed in the judgment of Aziz Basha.
Absolutely right. Now let me answer that. So what are the three things?
Basha extracted above. Therefore,
Yes.
Aziz Basha extracted above.
Yes. So the question is administered and established and administered, or established or administered is the Aziz Basha question. Why is Yashpal mentioned here? I put a question to myself. Yashpal is mentioned here because Yashpal had the provision under section 2F of the UGC Act, which said establish or incorporated. And they said in this context, it will have to be seen whether it is established or incorporated or established and incorporated. Because if your lordships will recollect in Yashpal, as Mr. Dwivedi also rightly pointed out, if you were to set up these one-room tenements all over his universities, all over the place, and then say, I have incorporated a university, that's a university, they said, no, you must have infrastructure, you must have facilities. So first establish and simultaneously incorporate. And that is why the word establish or incorporate, like administer and or incorporate or and administer and establish came into being. Most pertinent here is the amendment of the National Commission for Minority Educational Institutions Act 2004, because here the words used earlier were administer or establish, which by the 2010 amendment were replaced by administer or establish and administer. So that is why, keeping in mind that the question which in Aziz Basha remained undetermined was disjunctive or conjunctive, that is under Article 30 subclause 1, is it established and administered or established or administered? Similarly in Yashpal, the finding on established or incorporated, or should it be read as established and incorporated as in Yashpal? And more importantly, in the NCMEI Act, where the 2010 amendment changed the words from established or administered to established and administered, was the context that this had to be seen. My respectful submission in that light is that what your lordships are today being asked to decide on the basis of questions which have been framed by the appellants, not by the reference court, because the question they choose to frame, or one of the questions they choose to frame, is that whether the decision in Aziz Basha is internally contradictory in its reasoning on facts and in law, contrary to the authoritative decisions of this court rendered nugatory by subsequent statutory changes, and contrary to the constitutional dispensation of Articles 29 and 30. Now, my lords, would your lordships, I'm not for a minute saying that a bench of 7 judges cannot frame an additional question or the contours cannot be decided. But would your lordships ever in these matters go into an appeal, go into a review of a judgment who has been settled for 56 years and never questioned at all in any decision, not once doubted on the two issues of ANU being administered and the ANU being established? On both questions, their findings never doubted. And the only question which arose was, is it to be read as or and that is what gets referred. And that is why the reference order in para 8 uses the word not in plural. It says the question in Basha. It doesn't say the questions in Basha, because the only question which arose was the question of disjunctive or conjunctive, not all the three issues, because Basha ultimately decided three issues: administer, establish and administer, or establish or administer. And St. Stephens, of course, followed that finding and said that it has to be conjunctively read, not disjunctively. So our respectful submission, my lords, also linking this argument to the last argument of Mr. Dwivedi on stare decisis, is that would your lordships today, when neither does any court ever doubt the decision, and I'll go through those decisions today or tomorrow when I again commence my arguments, then none of those decisions, whether Mother Provincial, St. Stephens, TMA Pi, their facts have no bearing on Bhasha at all. At all. Secondly, not one of them even remotely has questioned the correctness of Bhasha at any stage in any form. On the issue of administer and establishment of AMU as an institution, not by a minority as held in Aziz Bhasha. I recommence tomorrow.
On what, to my mind, were the 8 key points that he has articulated in his piece. And those points are: 1, the greatest challenges can be solved not by fighting with each other, but by acting together. 2, technology gives us the means to address problems on a humanity-wide scale. 3, digital public goods that we have created are increasingly perceived by the world as delivering revolutionary progress. 4, India's experiences can provide insights for possible solutions. 5, our G20 priorities will be shaped by the interests of the Global South. 6, we will encourage sustainable and environment-friendly lifestyles based on trusteeship over nature. 7, we will seek to depoliticize the global supply of food, fertilizers, and medical products. And 8, we will encourage an honest conversation among the most powerful countries. So, as the youth of India, it is important that you are not only aware of the G20 activities, but also of India's approach that I have just summarized. Under the Youth 20 Engagement Group of the G20, India will focus on skill development, on the future of work, access to quality health, and youth as equal partners in the development agenda. During the year, in the spirit of Jan Bhagidari, I would encourage the youth to conduct and host a wide range of practical activities like university lectures, roundtable discussions, model UN conferences in colleges on G20 agenda, and welcoming G20 delegations, including through cultural performance at various meeting venues. Remember, each one of you present, physically here and virtually across, each one of you is an ambassador of India to the G20. I urge you to collectively be the radiant lotus of creative brilliance and generational optimism. Our success in the G20 will surely draw strength from all of you. And the G20 is in fact the premier grouping which is devoted to addressing the financial, economic and development challenges of the world. And in these difficult times, it is therefore particularly important that world leaders focus on the right issues that especially affect the more vulnerable sections of the world. Now, the attention obviously needs to be given not just to the problems, but equally, perhaps even more so, to finding viable solutions for them. In this regard, India's example is of increasing relevance to the rest of the world. Whether it is our last mile delivery done using digital platforms, a way of responding to the COVID and other public health challenges, or indeed the transformation in green and clean energy that we have seen in the last few years. There are very good reasons why today the world is taking a much deeper interest in us. The G20 presidency offers an opportunity to share our story with others, particularly those who may transpose some of our experiences on their performance or challenges. And it is also a time when we must become the voice of the global South that is otherwise underrepresented in such forums. Countries of Asia, Africa, and Latin America trust India to speak up for them. We have of late been in the forefront of expressing their concerns on fuel, on food, on fertilizers. And we share too the apprehension that sustainable development, climate action, and climate justice could be sidetracked due to more dominant issues. But our task will end not just with articulation. India has to take the lead in pushing for collective action, and that is exactly what we intend to do at the G20. Now, there are established mechanisms and working platforms to take forward various issues that come up in the G20 agenda. But the G20 naturally responds to the pressing issues of the day. It is also a tradition in the presidency, for the presidency, to flag concerns that are most immediate and seek support of the larger membership. Where India is concerned, some of the priorities are self-evident. Energy security and food security are two such examples. After the pandemic, there is a global expectation that more equitable solutions would be found for health challenges. And as the driver of the widely appreciated vaccine Maitri, the global South has hopes that India would take forward this cause. Our commitment to climate action and climate justice is again very well recognized. This is even more so in the context of national actions and policies on this subject in the last 8 years. Most of all, our digital prowess and its effective application on the ground, that has really caught the world's attention. While noting all these developments, let me address some specific issues that are likely to come up in the G20 context. As a civilizational state, it was imperative that India is not only conscious of its heritage and culture, but brings those perspectives to bear on contemporary issues. As we currently consider the challenges of climate action, it is natural that we reassert our innate reverence for nature and search for solutions that are not just material but also behavioral. We would seek to encourage a rethink around the world, both on how we produce, but equally important, on how we consume. Green transition at scale is possible only when climate action is converted into a people's movement. During our G20 presidency, we will spotlight life as in lifestyle for environment, with its associated environmentally sustainable and responsible choices at the level of individual lifestyles as well as national development. Only then will it lead to globally transformative actions, resulting in a cleaner, greener, and bluer future. We will make life a global movement, one that envisions placing the prevalent use and dispose economy with a circular economy. It intends to nudge individuals to undertake simple acts in their everyday life that can contribute to effectively address the challenges of climate change, environment degradation, energy crisis, and rapid sustainable growth. Pro-planet people adopting fundamentally sustainable lifestyles will change the way we do business in the 21st century. India will seek to be a catalyst of that change. When taking over the G20 presidency in Bali, Prime Minister Narendra Modi spoke about a sense of trusteeship. We want that message also to go out from the G20. That for the sake of future generations, for people like you, every generation should leave the planet in a better shape than it inherited it. After due deliberation, we have therefore taken up Vasudhaiva Kutumbakam, or One Earth, One Family, One Future, as our G20 presidency theme. Drawing from our cultural ethos, this is a strong assertion of beliefs in shared and common solutions. It may apply to climate action and life, where the power of example, the diffusion of technology, and the spread of best practices can make a decisive difference. The same drivers are even more powerful when it comes to digital delivery, in order to ensure that we leave no one behind. And remember, we have demonstrated it even at a time of extreme stress by undertaking successfully Vaccine Maitri. The G20 is a diverse platform that seeks to forge common ground on key issues among prominent countries. Our endeavor is to make that consensus more relevant through a wider process of consultation. Indeed, our very choice of guest countries is reflective of this intent. Harmonizing various interests is something that is ingrained deeply in India's history and culture. We have long been a pluralistic and consultative society who have debated issues openly before we arrive at a decision. Since this is deeply ingrained in our DNA, we have never been insecure with diversity. Our essential unity is not only the basis for pluralism, but it is also a source of confidence for engaging the world. As the mother of democracy, India's G20 presidency will be consultative, it will be collaborative, and it will be decisive. Having noted that, we must also recognize that the global order today is not truly reflective of the state of the world. Institutions and practices created 75 years ago still dominate global decision-making. A representative and democratic international order must press for change, not just in the United Nations, but in other international institutions as well. While we strive to progress on this broad agenda of issues, the G20 cannot be impervious to immediate developments that have a direct consequence on global well-being. This year, much of that debate has centered around the Ukraine conflict. As you all know, the Prime Minister had declared that this is not an era of war, and that dialogue and diplomacy alone can provide solutions. At Bali, the significance of this position was widely recognized by G20 leaders. In fact, the universality of this message is being appreciated as well. Many of you today would have read in the newspapers that you would have seen in the morning or read on your phones, Prime Minister's own thoughts about assuming the G20 presidency. And that, by the way, has appeared in newspapers across the world. Now, we should reflect on what, to my mind, were the 8 key points that he has articulated in his piece. And those points are: 1, the greatest challenges can be solved not by fighting with each other, but by acting together. 2, technology gives us the means to address problems on a humanity-wide scale. 3, digital public goods that we have created are increasingly perceived by the world as delivering revolutionary progress. 4, India's experiences can provide insights for possible solutions. 5, our G20 priorities will be shaped by the interests of the global South. 6, we will encourage sustainable and environment-friendly lifestyles based on trusteeship over nature. 7, we will seek to depoliticize the global supply of food, fertilizers, and medical products. And 8, we will encourage an honest conversation among the most powerful countries. So, as the youth of India, it is important that you are not only aware of the G20 activities, but also of India's approach that I have just summarized. Under the Youth 20 Engagement Group of the G20, India will focus on skill development, on the future of work, access to quality health, and youth as equal partners in the development agenda. During the year, in the spirit of Jan Bhagidari, I would encourage the youth to conduct and host a wide range of practical activities like university lectures, roundtable discussions, model UN conferences in colleges on G20 agenda, and welcoming G20 delegations, including through cultural performance at various meeting venues. Remember, each one of you present physically here and virtually across, each one of you is an ambassador of India to the G20. I urge you to collectively be the radiant lotus of creative brilliance and generational optimism. Our success in the G20 will surely draw strength from all of you. And the G20 is in fact the premier grouping which is devoted to addressing the financial, economic and development challenges of the world. And in these difficult times, it is therefore particularly important that world leaders focus on the right issues that especially affect the more vulnerable sections of the world. Now, the attention obviously needs to be given not just to the problems, but equally, perhaps even more so, to finding viable solutions for them. In this regard, India's example is of increasing relevance to the rest of the world. Whether it is our last mile delivery done using digital platforms, a way of responding to the COVID and other public health challenges, or indeed the transformation in green and clean energy that we have seen in the last few years. There are very good reasons why today the world is taking a much deeper interest in us. The G20 presidency offers an opportunity to share our story with others, particularly those who may transpose some of our experiences on their performance or challenges. And it is also a time when we must become the voice of the global South that is otherwise underrepresented in such forums. Countries of Asia, Africa, and Latin America trust India to speak up for them. We have of late been in the forefront of expressing their concerns on fuel, on food, on fertilizers. And we share too the apprehension that sustainable development, climate action, and climate justice could be sidetracked due to more dominant issues. But our task will end not just with articulation. India has to take the lead in pushing for collective action, and that is exactly what we intend to do at the G20. Now, there are established mechanisms and working platforms to take forward various issues that come up in the G20 agenda. But the G20 naturally responds to the pressing issues of the day. It is also a tradition in the presidency, for the presidency, to flag concerns that are most immediate and seek support of the larger membership. Where India is concerned, some of the priorities are self-evident. Energy security and food security are two such examples. After the pandemic, there is a global expectation that more equitable solutions would be found for health challenges. And as the driver of the widely appreciated vaccine Maitri, the global South has hopes that India would take forward this cause. Our commitment to climate action and climate justice is again very well recognized. This is even more so in the context of national actions and policies on this subject in the last 8 years. Most of all, our digital prowess and its effective application on the ground That has really caught the world's attention. While noting all these developments, let me address some specific issues that are likely to come up in the G20 context. As a civilizational state, it was imperative that India is not only conscious of its heritage and culture, but brings those perspectives to bear on contemporary issues. As we currently consider the challenges of climate action, it is natural that we reassert our innate reverence for nature and search for solutions that are not just material but also behavioral. We would seek to encourage a rethink around the world, both on how we produce, but equally important, on how we consume. Green transition at scale is possible only when climate action is converted into a people's movement. During our G20 presidency, we will spotlight life as in lifestyle for environment, with its associated environmentally sustainable and responsible choices at the level of individual lifestyles as well as national development. Only then will it lead to globally transformative actions, resulting in a cleaner, greener, and bluer future. We will make life a global movement, one that envisions placing the prevalent use and dispose economy with a circular economy. It intends to nudge individuals